And thank you everyone for joining us. I appreciate you taking the time. So first, just an overview of the agenda of what we're going to cover. We're going to talk about, what can you lien, who can lien. We're going to talk about what you need to do to perfect and preserve your lien rights. We're going to talk about the process of filing your claim of lien and ultimately potentially bringing a lawsuit to foreclose on the lien, and then what you can actually recover in such a lawsuit. And then we're also going to talk about managing liens of subcontractors and suppliers. So just as a high level overview of construction liens, they're created under Florida statute chapter 713, known as the construction lien law. And construction liens, I think most of us know, but they act like a mortgage and an encumbrance on the real property. And they're intended to protect persons or entities that are improving real property. So everyone in the construction process, potentially to certain levels, which we'll talk about, but contractors, subcontractors, suppliers. And then finally, lienors must strictly comply with the requirements of the construction lien law. The lien law is a creature of statute, and so it has a lot of timeliness type requirements that have to be strictly complied with in order to preserve your ability to file a lien to preserve your lien rights. Next slide, please. So first, I want to talk about the property that may be subject to a lien. And so under the lien law, the construction lien will attach to the owner's legal interest in the real property on which the improvements are being constructed. So that's important because if the party with whom you as the general contractor have a contract with doesn't actually own the property, you're not going to have any lien rights against the real property. And we'll talk about that a little bit. It comes up somewhat in the landlord-tenant context, but also comes up sometimes when people don't know for sure the party that they're contracting with is the actual legal owner of the real property. And under the lien law, the real property is defined to include both the dirt, the land that's underneath the improvements, as well as any improvements and fixtures that are on the real property. Those will all be subject to the construction lien. Next slide, please. So there are types of property that are not subject to lien, and largely that is government property. So state and local government property owned by the state of Florida or any city or town or county, those are all exempt under the lien law from construction liens. So, as a general contractor, you would need to look to the government entity for payment. You would not have any lien rights as to that property. Now, subcontractors, suppliers on projects that are over a certain monetary threshold, under Florida statute 255.05, the general contractor would have to provide a 255.05 Little Miller Act payment bond that would substitute for lien rights for that state or local government property. On federal projects, that land is also not subject to lien, and the contractor is not able to lien that property. But on those projects, there's the Miller Act, which is similar to the Florida Little Miller Act, on which subcontractors and suppliers may be able to look to in lieu of lien rights. Next slide, please. Another area where property may not be subject to lien rights is when a contractor is contracting with a tenant for improvements. The tenant's leasehold interest, meaning their ownership, their right to possession under the lease, will be subject to a construction lien, but the underlying landlord's real property will not be subject to a lien if the contractor has a contract with the tenant, unless the improvements that are being done are required by and essential to the lease, meaning the case law speaks in terms of the lease improvements must be the pith of the lease. That means they're not just permitted to be made by the tenant, but they're required to be made. Next slide, please. One back, please. There's a but, there's always a but. So even if the improvements are the pith of the lease, meaning they're required by the lease, the landlord can still prohibit a lien from attaching to the landlord's property if the lease also contains a provision in the lease that prohibits liens, and the landlord records either a copy of the lease with that provision or a short form memorandum of the lease with the lien prohibition provision in the public records before the notice of commencement for the improvements is recorded. So even if the lease requires the improvements, if it has that lease prohibition and it's recorded prior to the notice of commencement, then only the tenant's leasehold interest will be subject to the lien and not the landlord's interest in the real property. And as you can imagine, the tenant's leasehold interest has a lot less value to a potential lienor like a general contractor, because if you foreclose on it, all you get is ownership or the right to possession under the lease, and also the requirement to pay rent to maintain that provision, that right to possession. So it's not necessarily a great form of security for contractors in such instances. Next slide, please. So this kind of brings to point that especially for general contractors, it's really important, it's really critical that you do your due diligence when you're entering into a contract with an owner. And one big part of that is running a title search. A title search you can obtain for a couple $100, and from that search you'll be able to verify the true legal owner of the property to make sure that the party that you're contracting with actually owns the property, such that their property will be subject to the lien. You can also determine if there is a lease lien prohibition, because it will have to have been recorded in the public records. So you'll know if that is the case or not. And it's also important for you to determine if there's any prior mortgages or liens on the property. So if there are, large prior liens or prior mortgages, then that can affect the practical value of your construction lien if you have to go foreclose it. Because if there's a big mortgage ahead of your lien, if you foreclose the construction lien, it'll be subject to that mortgage. It'll be inferior to the mortgage, so it won't have as much potential value as a method to recover payment for you. Next slide, please. Another aspect of due diligence relates to the notice of commencement. And I think we all know what a notice of commencement is, but it's a document that has to be recorded in the public's records when a project is being started. It also has to be maintained posted at the project site, a certified copy. And you can think of the notice of commencement as sort of the source document that has all the information that's required for a lienor to know what they need to do to file the lien. So it would have the legal description of the property. It'll have the owner's name and address. It'll have the owner's legal interest in the property, all the information that's needed for filing the claim of lien. The notice of commencement must be signed by the owner. That's in the statute. But there's actually a very recent case out of Florida's 2nd District Court of Appeal, the Edwin Taylor Corporation versus MERS case that came out in 2020. And the court there looked at the issue of, well, what if a contractor signed the notice of commencement? Even though it's not technically in compliance with the statute, the court held that it was sufficient regardless, and it did not invalidate the notice of commencement. Still, best practice is to make sure that the owner signs the notice of commencement and not the contractor. A notice of commencement is going to be effective for 1 year from the time it's recorded, unless it specifically states in the notice of commencement that a longer time period will be in place for performance of the contractor, for the contract. Also, a notice of commencement can be amended within that 1 year time period to extend the time as well, but that has to be done prior to the expiration of the notice of commencement. And notice of commencement are also critically important because if you file a claim of lien, it will relate back, meaning even though you file it, 8 months after the notice of commencement, for purposes of priority in comparison to other liens or mortgages, the lien will be deemed to relate back to the date of the recording of the notice of commencement. So it's important that if a lien's filed, it's within the time period of the notice of commencement so that it gets the benefit of the relation back. So we've talked about, what property is subject to liens and what property is not subject to liens, and we talked about due diligence and how important that is. So now I want to cover which entities actually have lien rights under the lien law. And Florida Statute 713.01 defines the lienors in Section 18, and that includes contractors, subcontractors, subcontractors, laborers, material men or suppliers, and then design professional lienors. And in addition, the lien law also provides that a lien can be assigned. So lien rights are freely assignable, meaning if you have a lien, you can sort of sell it or assign it to another party who could then pursue it on your behalf. Next slide. So the lien law defines the term contractor in Florida Statute 713.018, and it says contractor is a person other than a materialman or a laborer who enters into a contract with the owner of real property for improving it, or who takes over from a contractor as so defined the entire remaining work under the contract. So a contractor is the party who has a direct contract with the owner, or takes over a contract for another prior contractor that had a contract with the owner. Contractors are going to have lien rights on any residential or commercial project, except where the contract price is $2,500 or below. In that case, nobody has any lien rights for those types of smaller dollar contracts. One other thing to note is that the statute also defines contractor to include an architect, landscape architect, or engineer if they improve real property pursuant to a design build contract authorized by Section 489, 103.16 of the Florida statutes. So in that instance, contractor can be a little broader in the design build context. Next slide, please. So the lien law also defines subcontractors, and under the lien law, only subcontractors with a contract with the general contractor and subcontractors who have a contract with a subcontractor have lien rights. What that means is that third tier subcontractors, subcontractors, in other words, do not have any lien rights under the lien law. And it's important to know as a general contractor, which levels of parties in the contracting chain have lien rights. So, when you're dealing with lien releases and potentially dealing with claims of lien, to understand who has lien rights and who doesn't. And importantly, third tier subcontractors do not have any lien rights under Florida's lien law. Next slide, please. So the lien law also talks about material men, which is another word for suppliers. Under the statute, they must furnish materials to an owner, contractor, subcontractor, or subcontractor to qualify as a materialman and have lien rights. So in other words, suppliers to third tier subcontractors and suppliers to suppliers do not have any lien rights. In order to qualify as a supplier, you must only supply the materials. If you're doing any labor or installation in connection with that, you're considered a subcontractor versus a supplier. In order for materials to be able to be part of a construction lien, they have to be delivered to the site and actually incorporated into the improvement to give rise to lien rights. Otherwise, they're not lienable. There's an exception to that, and that's for specially fabricated materials. And that's a fairly limited exception, meaning that the materials have to be created specifically for the project and they can't be reused on another project. So an example might be some, specially cut sheet metal for a particular project or application. You can't use that on another project. And so even if that is not actually incorporated into the work, it can be lienable because it's considered specially fabricated materials. Next slide, please. So we've talked about entities that have lien rights, and then there's the list of entities that don't have lien rights. And we've talked about this a little bit already, but those include third tier subcontractors. Those include suppliers to a supplier or a supplier's fabricator. Those include suppliers that sell goods that are not designated for any particular project or that are not actually incorporated into a project, as we discussed. Government property obviously is not subject to lien, so if you're working on, anybody working on a government project doesn't have lien rights. And then on projects that that have private payment bonds under Florida Statute 713.23, subcontractors, suppliers don't have lien rights. They look to the bond that the contractor puts up. Only the contractor would have lien rights on those types of projects. Also, if a contractor is unlicensed or doing unlicensed work, that's a complete defense to lien rights. Unlicensed contractors have no lien rights. And then finally, if a lienor files what's called a fraudulent lien, they lose their lien rights. And fraudulent lien is defined in Florida Statute 713.31. And what it says is if a lien is fraudulent if the amount of the lien is willfully exaggerated, or it includes claims for work not performed, or the lien was compiled with such gross negligence to amount to a willful exaggeration. If that occurs, it's a complete defense to the lien. Now that doesn't cover just sort of run-of-the-mill, mistakes. It takes, intentional exaggeration of the amount of the lien, or actual, compilation of the lien with such gross negligence that it amounts to a willful exaggeration. Next slide, please. So I want to cover this concept, and we talked about this a little bit with the materials having to be incorporated into the property, but the work that's being liened for must permanently improve the property. So with the exception of professional services, the labor, services, and materials must be part of an improvement, which is defined in the lien law to provide a permanent benefit to the property. So what that means is there are no lien rights for services that do not permanently improve the property, such as cleaning, maintenance, or landscaping. And there's a case cited here that talks about the maintenance landscaping, and that would not be landscape installation, but maintenance type landscaping. And what the court in this Legault versus Suncoast Lawn Services case said was that maintenance landscaping services do not bestow a permanent benefit upon the land and do not entitle a laborer to mechanics lien. So maintenance type lawn services don't give rise to lien rights, but a landscaper that comes in and installs plants and does work to permanently improve the project as part of a construction project does have lien rights. And then one thing on the cleaning, I mentioned that cleaning doesn't give rise to lien rights. There is an exception to that for what's defined as final cleanup to prepare a structure for occupancy. That is specifically included in the lien law as part of the definition of an improvement under section 713.0114. So that final cleanup is lienable versus just maintenance type cleaning. Next slide, please. So the other area that there's no lien rights for sort of non-scope work. So you don't have lien rights for the cost for work that's defective. You also don't have lien rights for the cost that you expend to repair defective work. Similarly, you don't have lien rights for warranty work because that's work that should have been done, appropriately in the first instance. And again, as we discussed, there's no lien rights for unlicensed work. Next slide. So I want to talk briefly about change work. So the lien law has the definition of extras and change orders, and what those are defined to mean are labor, services, or materials that are authorized by the owner and added to or deleted from a previous contract between the same parties. And so change order work is lienable if it's properly authorized by the owner. So if there's a signed change order, no doubt that is lienable. You can file your construction lien. It gets a little bit murkier where you get into a situation where maybe the contract requires all change orders to be in writing, but there's not a signed change order for a particular work and the contractor's making a claim that there was a change. Generally, if the facts can be established that notwithstanding that requirement for the change orders to be in writing, that the parties have through their actions waived that requirement through course of dealing during the course of the project, then that will be lienable, and there's a lot of cases that talk about that. So, change order work, as long as you have a good faith basis to argue that the owner has approved it, you should be able to include it in your construction lien. Now, there is a difference when you start talking about damages for breach of contract, such as lost profits or delay damages. Those are not lienable because they're not considered labor, services, or materials to improve the real property under the lien law. And that's there's a bunch of cases on that, but one cited here pretty recently from 1998 is the onion skin versus DeCiccio case. And what the court held there was that delay damages were not lienable under the lien law. So that wraps up my portion of the presentation, and I'm going to shift it over to Joby to handle the next section. Thank you.
Great job, Ron. Thanks. So now we're to the point where we are preparing a claim of lien. And that section of the lien law is governed by 713.08. And that section provides that the claim of lien can be prepared by the lienor or a lienor's employee or certainly an attorney. But a claim of lien cannot be completed by a non-lawyer lien service. We see that from time to time, and as you'll see in the next slide, that will be a unlicensed practice of law issue. So the Florida Bar versus CARMEL addressed this issue where the defendant was operating a lien filing service, advertising to the public that they could prepare and file those types of liens, providing a kit, advising on the time of notice and other procedural elements of the Florida construction lien law. And they were also writing letters on behalf of their customers threatening to file those liens. And the Supreme Court of Florida agreed that with the Florida Bar that CARMEL was causing grievous and irreparable harm to individuals and kept them from engaging the acts complained of and the practice of law by preparing, advising, sending out construction claims of lien. So clients always ask, what do I get if I recover under my lien if I'm successful? Well, number of things. One is you can foreclose on real property. You can get a money judgment. You can potentially get your litigation expenses, prejudgment interest, and attorney's fees. Sticking with the issue of attorney's fees, those are governed by Florida statute section 713.29 in the context of the lien foreclosure action. And the Supreme Court of Florida, however, has said that the award of attorney's fees under that statute is not absolute. In other words, the court can determine that neither party prevailed and not award either side attorney's fees. And that's a bit of a head scratcher for some folks, but I always caution clients that even though the statute provides for attorney's fees, it's not absolute, and the court could ultimately determine that no one gets them. Transfer bonds. Most of you on this call are probably familiar with payment bonds and performance bonds. This is another type of bond that gets property clear of liens. So a lien gets recorded. Under 713.24, there is a mechanism by which a bond can be put in place to remove that lien from the property. Sometimes contractors require their subcontractors to bond liens off, and this would be a way of doing that. Similarly, general contractors may require their subcontractors to do the same, and 713.24 describes the mechanism on accomplishing that. There is a statutory dollar amount for which the lien has to be provided. That's the amount of the lien that was recorded on the property, plus interest at the legal rate for 3 years, plus $1,000 or 25%, whichever is greater. So that's the amount for which the transfer bond needs to be placed in order to remove the lien from the real property. And once that happens, the lien is no longer an encumbrance on the real property. The bonds it serves in its place. So oftentimes, once a lien is recorded by a general contractor, there will be some documentation that comes back to the general contractor that can have a devastating effect on the lien itself. In other words, they can potentially wipe out your lien. So need to be on the lookout for a number of things, and they're all prescribed by statute, and don't see them all of the time, but they do surface every now and then, and you just need to be aware of anything that comes across your desk that references a lien or talks about your lien after it's recorded. Pay particular attention to that, because they have very specific timing requirements and for the most part very short time requirements, or you lose your lien rights. So those three things to be on the lookout for are a request for a sworn statement of account, a notice of contest of lien, and a show cause complaint. So the request for sworn statement of account is governed by 713.16, and that allows the owner to require the lienor to provide a copy of its contract, as well as all amounts that are due or that may become due. And you certainly want to make sure that the information that you provide in that sworn statement of account is accurate and truthful, because there are criminal penalties associated with not doing that. And you have 30 days to furnish the information that's required in that sworn statement of account, or you lose your lien rights. So 30 days after you get a request for sworn statement of account, if you don't do something in response, you will no longer have a lien. Notice of contest of lien is another mechanism to shorten the time period for which you can foreclose on your lawsuit or your lien goes away. All of these things are ways to shorten the time that the lien hangs out there. Some people will serve these hoping that the lienor doesn't understand or doesn't pay attention to them, and really is the effect of the lien goes away. So just be paying attention to the notice of contest of lien. That gives you 60 days from when a owner files a notice of contest of lien to file suit to enforce that claim of lien. That's a lien foreclosure action that you would need to file within 60 days from when the notice was mailed to you as the lienor. A failure to file your lien foreclosure action within that 60-day period will again extinguish your lien rights. So pay attention to that 60-day time frame if you get the notice of contest of lien from the owner. Finally, a show cause complaint. You're going to know that when you see it in all likelihood, because that's going to be a lawsuit. That's going to be a complaint that someone serves, and like any lawsuit, it gives you 20 days to respond to it. And if you don't respond appropriately, meaning either you answer it, you foreclose on your lien, potentially giving the court a reason why you shouldn't have to be foreclosing the lien at this point. Best practice is just to go ahead and answer it, file your lien foreclosure action within that 20-day period. If you fail to do that within the 20-day period, you're going to lose your lien rights.
All right, thank you, Joby. Now let's turn to how you manage the liens of your subs and suppliers, how you as the prime contractor, what you need to know and what tools and processes are there for you to employ to manage those liens of your subs, suppliers, and the lower tier subs and suppliers. So the things on your screen are the things that you need to know and that we're going to cover with the upcoming slides. Let's start with your obligations to the owner. Your contract with the owner may contain provisions that obligate you to do things or pay for things if one of your subs or anyone records a claim of lien. So on the screen is language from the standard AIA A201 general conditions. And you may not know this, but as the contractor, you're contractually required to defend and indemnify the owner from any lien claim. Again, that's from your subcontractors or anyone below them. So, what does that mean? That means you're responsible to pay or to reimburse owner for all damages, all attorney's fees, all litigation expenses involved with that lien. How do general contractors typically deal with that requirement? When one of their subs or anyone records a lien, a claim of lien, you can use the transfer bond that Joby just explained to us, that takes the lien off of the real property and puts it onto the surety bond that you paid for and furnished. I will point out that this language in the AIA only applies if the owner has actually paid you. If your sub has a lien because you didn't pay your sub because you didn't receive payment from the owner, then you don't have an obligation to protect the owner from that lien. In fact, in that case, you would prefer that the sub bypass suing you and go to the owner through that lien claim, looking for payment. So that was your obligations in your prime contract. What can you do with your subcontract language? There's at least two options. They're both on the screen here. The top bullet point is some language in a subcontract, which acts the same as the prime contract language that we just looked at in the AIA. So in other words, your subcontractor becomes responsible for any liens filed by its lower tier subs and suppliers and has to defend and indemnify you against those. Also, this particular provision on the screen gives you the option of direct paying subs and lower tier suppliers and reducing the subcontract price. So if you may often hear joint checks, a joint check provision. This is similar, but it doesn't require a joint signature by the sub. And if you become concerned that your sub is not paying its subs or suppliers, you could use this language to your benefit to protect from liens from them. The bottom bullet point is another option for language in your subcontract. It says that if your sub does not get paid because you did not get paid by the owner, then the sub only has payment claims against the owner and not you. In other words, the sub cannot sue you for non-payment. So these are just things to think about for your subcontracts. Next, I want to point out that pay if paid provisions may not provide you the protection that you think it may. It does not insulate the owner's property from lien rights. A sub can still lien the project even if the subcontract contains a pay if paid provision. And we see sometimes that people don't understand that. Also, if you furnished a 713.23 private payment bond to protect the owner's property from liens, a pay if paid provision does not prevent a claim against your payment bond. And then last, I want to point out this concept called a conditional payment bond. It's under a different Florida statute. It's under 713.245. So pay if paid provisions are relevant if you've furnished this type of bond, and there would be no claim against your conditional payment bond if the subcontract had a pay if paid provision. However, the sub could still put a lien on the owner's property. The conditional payment bond doesn't protect the owner's property. I also want to point out the effect that of subcontractor payment bonds. Some general contractors do, and it's an option for general contractors to require their subs to post their own bonds, just like a the owner may require you as the GC to post bonds. But don't be misled into thinking that having your sub post its own payment bond will protect against liens on the property, the real property. Sub payment bonds are they're what's known as a common law bond, as opposed to a statutory bond. And common law bonds don't insulate the owner's property against liens. Only the 713.23 statutory payment bond that you as the prime contractor could furnish does that. Notice to owners, there's some best practices to point out here. During the project, and it's good practice for you to create and maintain a list of all vendors working on the project. That would include lower tier subs and suppliers. And I would say, even if they have not served a notice to owner, it's still good practice to identify who those entities are, who those people are. And it's belts and suspenders. It's not absolutely necessary, but it is good practice to require lien releases from subs and suppliers, lower tier subs and suppliers, even if they have not yet served a notice to owner. You're probably aware that a notice to owner must be served within 45 days of first furnishing, and that if not, even if a day late, because the statute is strictly construed, that if it's not within 45 days, then that sub or supplier has no lien rights. So accordingly, it's good practice to create and maintain a list of parties that have served a notice to owner timely. This may require that you work with the owner to identify those notice to owners, because your direct subs and suppliers aren't required to copy you as the contractor. They serve it directly on the owner. Lower tier subs and suppliers are required to send you a copy of the notice to owner. And having that list of parties that have served notice to owners will help you, protect the owner's property against liens by ensuring that you get lien releases from them. In addition to everyone that has served a notice to owner, I would say it's good practice to require a lien release from everyone working on your job, but certainly anyone that has served a notice to owner, you need to obtain a lien release from them before you make payment downstream. And you need to do this for every payment you make to a sub or supplier. It should be your standard practice that you don't cut a check to one of your subs or suppliers unless they provide their own lien release to you, as well as any sub or supplier underneath them. I do note that if you do not need to get a lien release from a sub, because they don't have lien rights, as Ryan explained earlier in the presentation. What form of lien release? The lien release is a protective, an important tool to protect the property, but the form controls what actually gets released, and it may or may not be providing the protection that you desire. The typical form is the one found in the Florida Statute 713.20. It sets forth, word for word, ready to be copy pasted into your own document, the lien release form. However, you can require a different form if you do so in your subcontract. I point out that the statutory form is what is unconditional as opposed to conditional. However, the statute in subsection 7 allows you, or allows the lienor to add language to the release to make it conditional. There are two different types of lien forms at your disposal. One is what's called a through date certain. The other is a sum certain. And the form in the statute is a through date certain. So what does that mean? That you're releasing all of your lien rights for everything that occurred up through that date, regardless of the dollar amount that you got paid. In other words, if you haven't billed for something up through that date and you provide a lien release through that date, you've lost your lien rights for that work that you had not even billed for yet. So the other option is a sum certain, and that is regardless of date. It doesn't state a date. It doesn't state that you're releasing your lien rights through a certain date. It just says you're releasing your lien rights in the dollar amount of blank, whatever it is, and that's typically whatever you're getting paid in exchange for that lien release. A practice pointer, look out for changes to your form or the reservation of claims, language added to the form, reserving lien rights on certain claims. I've seen, and I've actually helped a subcontractor do this to a general contractor that had a certain form in the subcontract, and we added some additional language in the fine print of the form, which better protected the subcontractor. So even though it looks like even though the release you're getting from your sub looks like your form, take a close look at it to make sure they haven't changed anything. Some tools that you can use as the prime contractor against your subs or suppliers. And these are similar to what Joby explained that an owner can use against you as the prime contractor. So in 713.161, you as the contractor can demand a copy of the contract and the statement of account of the amount owed by any lienor or two. You can send this demand to any lienor contracting with your sub or supplier. So the subs and the suppliers to your subs. You can send them a demand. They have to provide a copy of their subcontract or purchase order, and provide you a sworn statement of the amount owed by your sub to them. If they fail to do that, or they provide you bad information, it doesn't affect their lien rights per se, but it does give you a cause of action for damages resulting from their failure to provide you the correct information. The other two, 713.162, that's the request for sworn statement that the owner can serve. If you're cooperative with your owner, you could have your owner serve it. You can't, as the contractor, necessarily serve a request for sworn statement under 713.16 subsection 2, but you could ask the owner to do it. However, under subsection 4, you can serve a request for sworn statement if you furnished a 713.23 bond, and if the lienor doesn't respond within 30 days of your request, then they are deprived of their claim against your bond. And then real quickly, I just want to remind you of the transfer bond option at your disposal. Joby covered it thoroughly previously, but if one of your subs or suppliers or anyone under them records a claim of lien, this is most likely going to be your tool to use at that time, especially if you're required by contract. Thank you, and I'll turn it over to Nikos to guide us through any Q&A.
Yeah, thanks, Austin. So let's just jump in, and I'll also invite folks once again to submit their questions for the Q&A. If you haven't used this platform before, just as a reminder for you. It's on the right side of your screen. Looks like 2 speech bubbles with a question mark in it. You can submit your question there and also choose to submit it anonymously if you'd like to do that. We have a few that were pre-submitted. We'll start with those. The first question we have here is, what happens if a project is located in 2 counties? Where would I record my lien?
Nikos, I'll take that one. You should record it in both counties to be safe.
Okay, good. Very simple answer. Thanks, Joby. Appreciate that. Here's another one. It says, how do I force my subcontractors and suppliers to provide the type of lien release that I actually want from them?
That's a good question. So you have to dictate that in your contract, in your subcontract, or in your purchase order. And you can do that one of 2 ways. You can state that they have to provide a lien release in a form to be provided by you or a form acceptable to you. But there's a better way, and that's to attach a copy of the release form to the contract. So Exhibit A to your subcontract would be a copy of the lien release form. And then within the body of your subcontract and the payment provision, set it forth as a condition precedent that they have to provide it in that form. Otherwise, if you don't put it in your contract, if you don't have that requirement in your subcontract, you cannot force them to provide you with anything other than the form set forth in the statute. And the statute itself says that plainly.
Excellent. Thanks, Austin. Seems like we have time for another one here. So what are some ways a contractor can try to protect itself when working for a tenant when the lease has a lien prohibition?
Thanks, Nikos. I'll take this one. This is Ryan. So first off, the one thing I forgot to mention when I was talking about this, the statute does in 713.10, it does give the contractor the right to serve a written demand on the landlord for a copy of the provision in the lease prohibiting liabilities for liens. And the landlord is required within 30 days of receiving that demand to provide a sworn copy of the provision. And if the landlord fails to do that in a timely manner or submit something that's false or fraudulent, then the landlord's property will be subject to the lien. So that may be a way, even if you're not sure whether that lease prohibition's there, you send that written demand to find out for sure, and potentially to create lien rights if the landlord fails to timely respond to your written demand. If there is a lease prohibition, and you know that for sure, then some other options you might be able to consider or negotiate with your tenant contracting party is potentially have the tenant put up a letter of credit. That may be a way that in lieu of lien rights, you would have the right to look to a letter of credit if there are payment issues. You can also try to negotiate if the tenant's improvements are being funded through a lender. You can try to negotiate requirements for the lender to potentially either issue payment as a joint check or issue payment directly to you as a contractor to give you a little more protection. And you could also potentially try to work with the tenant to see if the landlord will agree to waive the lease prohibition on liens. Now none of this may be attainable, but these are ideas of ways that you could potentially try to protect yourself as a contractor dealing with a tenant on tenant improvements.
Good advice. Thanks, Ryan. Seeing no further questions, just to the panel here, Austin, Ryan, and Joby, is there anything else worth adding on the topic of lien law for prime contractors before we adjourn? All right, well, I appreciate everyone's time. We appreciate the attendees for joining us. We will continue the series. We'll follow up with some information about where the series will head from here. We hope you'll all stay tuned, and as always, get back to us with any feedback or any topics you'd like us to consider. Our contact information is there on the screen. You can find out more about any of our presenters on our website. It's jimersonfirm.com. Otherwise, we appreciate you all, and we hope you have a great rest of your week.
Thank you, everybody.
Thank you.